Draft amendments to the Tax Administration Act were published for public comment by National Treasury in July. Notably, there are proposed amendments that bolster the South African Revenue Service's information gathering powers. Dr Beric Croome is the chairman of Saica's Tax Administration Subcommittee. Beric, a proposed amendment to Section 46 of the Act, quite subtle. Currently, this allows SARS to request, I quote, relevant material from taxpayers and third parties. It could be amended to refer to information, documents, etc., material that, in the opinion of SARS, is foreseeably relevant. What's the reason for the change, and does it mean that SARS can now request a slip for a cappuccino I expensed 6 months ago to my employer's account?
It's a difficult one, Hannah. I think SARS possibly has become frustrated with what is happening in practice, that taxpayers are being asked to supply information and taxpayers are questioning that and saying, are they actually entitled to that? So they're trying, I think what they're really trying to do with this amendment is to ensure that it's SARS that must decide whether the information is relevant, not the taxpayer.
Yes. Is that reasonable?
I have some concerns there because, SARS has to operate within the parameters of the law, which is also ultimately subject to the Constitution. They can't just do things as they wish. They are constrained by the law. But what does happen, I think, is they often request information, and sometimes it is on a shotgun approach as opposed to being specific information. And taxpayers, I think, have the right to look at that request and see, is the information actually what is envisaged in the statute. The Section 3 of the Tax Administration Act requires that the information is directly related to the administration of a tax act. So where a person files a tax return, take a natural person, we're busy with filing season at the moment, the tax return goes in, SARS then responds on the e-filing and says, there's a discrepancy in the information submitted and what we've got, please supply your tax certificates, your proof of deductions, retirement annuity certificates, medical certificates, etc. Now there can be no question about that SARS is entitled to that because that's directly related to the return that's submitted. Because what changed a lot also was in the old days, probably pre-97 or thereabouts, we used to submit manual paper returns which contained all the documents.
Yeah.
You're now submitting tax returns electronically and there's no documents attached.
Sure.
So SARS needs to, and it has a duty to verify that information. It's getting a lot of information from third parties, which it's allowed to get through the Act. The banks have to supply details of interest. It can get details of medical contributions from funds. They can get details of contributions to pension, provident, retirement annuity funds. So SARS stands possessed of a lot of information and does cross-check that to what's supplied in the return. And will then, where there is a difference, or typically where there's a refund, they will ask the taxpayer to file that information. The more complex area is, I think, in the large corporate environment where SARS is now starting to conduct an audit and starts requesting comprehensive information. They're wanting copies of board minutes, executive committee meetings, remuneration committee minutes, and then sometimes they're going back 15 years.
Sure.
Asking taxpayers to supply all of that. Now the question there is SARS entitled to all of that? Where there are things in there which might assist SARS in assessing a taxpayer to tax, clearly SARS has an entitlement to that. But where there's commercial information which is sensitive regarding processes or commercial transactions which might be under consideration, which should be protected. I think that's going beyond what SARS is entitled to, and that's often, I think, where some of the tension comes in as to whether that is relevant for purposes of tax. But the concern, I think, is if the amendment does come through, and we don't know what the final outcome will be after the representations that have been made,
yes,
is that it's referring to, in the opinion of SARS, is foreseeably relevant. It's sort of almost putting a discretion on SARS, and the concern one has is a SARS official request information and the taxpayer will challenge it, and the SARS official will respond and say, I'm saying I'm entitled to it and therefore I must have it. That to me is not the right way of looking at it. Taxpayer, I think, would still be entitled to determine whether it's actually necessary for purposes of administering the tax laws of the country.
And I think that's important, as you mentioned. Taxpayers need to know what their rights are and how to exercise those. Just quickly, you mentioned third parties, and one of the other amendments is sort of SARS requesting that third parties hand over information relating to taxpayers who it might be investigating. Who or what would count as a third party? If you can give us a very sort of illustrative example, and how would this affect them, these amendments?
One classic example is the bank.
Yeah.
SARS does, and historically also under the old Act, would approach a bank and say, we require information on X, Y, and Z. Please provide copies of bank statements, other information pertaining to their affairs at the bank. Now, the old Act made it quite clear in that case that the bank would have to supply the information, and in fact, SARS could say to the bank, you're not entitled to advise your client of this request for information. They still seem to do that today, and I think there's probably a legal basis for that if I look at the rules on confidentiality of information in the Tax Admin Act.
Okay.
So SARS can go to a bank, stockbrokers, or any other party and request specific information on the taxpayer to assist them in determining liability to tax. The concern I have is SARS should be doing that as a last resort where the taxpayer is not cooperating and not giving the information themselves. SARS shouldn't be going to the bank as a first port of call to request that information. The law doesn't deal with that aspect. To me, it would be better if the law said or dealt with the power in such a way that where the taxpayer doesn't cooperate, SARS can then resort to the third party. SARS shouldn't be burdening the banks with that at the outset, unless the taxpayer is not cooperating.
Beric, when do you expect all of these to be finalised, all of these amendments?
Well, Hanna, the process has run its course because the bill was issued for public comment in July. There then was consultations with the Treasury and Revenue in the way of meetings with those organisations. There were hearings on the bills at the Standing Committee Finance, late August, early September, and Treasury and SARS then prepare a response document commenting on the submissions they received on the amendments, which will give an idea of what SARS' Treasury's response is. But normally the final bill is tabled at the same time as the mini-budget, which this year is 22nd of October. So around that time, either on that day or shortly thereafter, Minister Nene will introduce the mini-budget, and either the same day or the next day he will table the final version of the bill, which will then go through the parliamentary process for adoption.
Dr Beric Croome is the chairman of Saica's Tax Administration Subcommittee.